What if I told you that one overlooked name on a patent could cost you millions, could actually invalidate your patent? Stay tuned, because I'm going to reveal why getting the inventors correct is not just a legal technicality, it's a business necessity. Because if you get it wrong, you may have financial loss, lawsuits, and missed opportunities, just to name a few of the risks. By law, all inventors have to be named on the patent application. And by law, they initially own the invention in equal, undivided parts. In order for your business to own that patent, you need to get assignments from all the inventors. And this is pretty typical whenever you file patent applications. You have the inventors assign their rights through an assignment document back to the company. Missing someone or including the wrong person, though, can create issues and lead to invalidation of the patent. A competitor could challenge your patent's validity by claiming you had deceptive intent when you didn't correctly name the inventors. The other problem is unnamed inventors can actually license the patent to your competitors because they have an equal, undivided interest in the patent unless it gets assigned over to your business. This isn't just about compliance, it's about control. If you don't get it right, you might lose control of your patent altogether. Your business thrives on intellectual property. It's what gives you that edge in the market. Protecting your intellectual property is more than just filing paperwork. It's about ensuring you're bulletproof when investors, partners, or competitors start digging into that intellectual property. I'm going to give you some examples of actual cases where naming the wrong inventor killed the lawsuit and cost millions in damages. Blue Gentian versus TriStar Products. This was a patent involving a watering hose, and Blue Gentian did not include one of the inventors on the patent application. That inventor licensed his rights to another company that was actually being sued by Blue Gentian, TriStar Products. The court agreed that the unnamed inventor had equal rights, and this resulted in the loss of all damages, an injunction, and Gentian's exclusive rights to sell the product. It was a devastating loss that could have been avoided with proper inventor naming. In another case, Ethicon, a manufacturer of surgical instruments, filed a patent infringement suit against a competitor, United States Surgical. The inventor named on the patent was Dr. Yoon. Yoon granted Ethicon, the plaintiff in the lawsuit, an exclusive license to practice his invention. During the lawsuit, U.S. Surgical, the defendant, learned of a potential co-inventor, Mr. Chu. Chu was an electronics technician who collaborated with Dr. Yoon for 18 months. U.S. Surgical asked the court to add Chu as an inventor. The court agreed, finding that Chu was in fact an inventor of the patent. The court found that there was corroborating evidence that supported Chu's assertions and that he should have been named as an inventor. The court then dismissed Ethicon's lawsuit because Chu had granted U.S. Surgical a retroactive license to the patent. And the technical term for this loss is, ouch, we lost all of our rights because we didn't include all the inventors. In a more recent case in 2020, Ono Pharmaceuticals learned this lesson the hard way as well. They collaborated with Dana-Farber scientists Gordon Freeman and Clive Wood on a cancer treatment. The invention was very important. In fact, one of the inventors was awarded the Nobel Prize for the invention. 8 patents were issued to Ono, but none named Freeman or Wood. A lawsuit followed, and the court determined that Freeman and Wood should have been named as inventor. Dana-Farber is now a co-owner of all 8 patents and is actively licensing the technology competing with Ono. So imagine launching a groundbreaking product only to find out an ex-employee you didn't credit now owns a piece of that technology. Just a quick interruption here. I wanted to offer you a complimentary guide and checklist to locate your own intellectual property. There's a link below. Click on the link and you'll automatically get that document, and you can use that to try to figure out what you have in the way of intellectual property in your business, and it gives you some thoughts on how to protect that intellectual property. I will also put you on my email list. Every week I send out an article regarding intellectual property of interest to business owners. So please click on the link, take advantage of this complimentary offer, and I look forward to talking with you further with regard to your intellectual property. Now back to the video. Thank you. Getting the inventors wrong can lead to lawsuits, financial penalties, and the potential loss of investment opportunities. Investors care about due diligence. One mistake can make them walk away. What do you need to do? You need to document the invention process thoroughly, keep clear records of who contributed to what, and work with an IP professional to audit your IP and ensure your inventors are properly listed before filing, and if you made a mistake, get that mistake corrected as soon as possible. There's processes through the United States Patent and Trademark Office that allow this to be corrected as long as there was no deceptive intention. This isn't something to leave to chance. Your business deserves the strongest protection possible. If you're wondering whether your inventors are listed correctly, or if you've already filed, want to double check and make some changes, schedule a call with me. Together we'll make sure your intellectual property is ironclad. Don't let a simple mistake put everything you've built at risk. Reach out now to secure your business's most valuable assets. Thanks for watching, and don't forget to like, subscribe, and share the video with fellow entrepreneurs. See you next time on IP Insights with the IP Guy. Thanks for viewing.